Hey folks, this is Rob Wells here with you from the law office of Robert M. Wells. Our office helps landlords and property managers deal with their landlord-tenant situations and problems. In this video, I'm going to answer the question. So I'm a single-family homeowner or condo owner, and I know my property can be exempt from the Tenants Protection Act, but I know that there's some type of disclosure that I got to have in my lease. What happens if I don't have that disclosure in my lease? And that question was posed by another viewer, Peaches P. I appreciate the comments, Peaches. I'm going to answer this question for you and any other person that's in this situation. Before I begin, landlords, tenant, and property managers, if you're facing a situation where you may not have this exemption for your single family home or condo, please let me know. Let us know. Our information's down below. Let's begin. So let me backtrack a little bit. The question is, and this is an exemption that affects predominantly single family homeowners and condo owners. Am I exempt from the Tenants Protection Act? Technically, yes, but the exemption is contained in Civil Code 1946.2 E8. It's technically, I would dub it the separate and alienable from any other title or unit exemption. It's a mouthful. What that means is hey, if you only have one unit and it's only on one title, there's only one unit on this property. An owner that is not a real estate investment trust, as defined in the Internal Revenue Code, a REIT basically, or a corporation, or an owner that holds title to property in an LLC, which at least one member is a corporation, or as of this year, management of a mobile home park for mobile homes. If you're just a natural person and you just hold title, or you're a natural person that just has an LLC and there's no corporate member, you are exempt from the Tenants Protection Act for your single family dwelling or condo unit, basically. You have this exemption again in subdivision EA of the Tenants Protection Act, Civil Code 1946.2. The question that Peaches and some other landlords have posed is, okay, Rob, under subdivision E8, I know that there was like a deadline if my lease was entered in on or after July 1st, 2020, and I don't have that exemption saying that, verbatim, I am not subject, this property is not subject to the rent limits imposed under section 1947.12, etc. It's a verbatim disclosure that's in the civil code that you have to have in your lease agreement. What happens if I don't have that? Well, if you don't have that in your lease as of, and you entered into a lease on or after July 1st, 2020, you're technically subject to the Tenants Protection Act until you get that addendum or disclosure inside your lease. And the simple solutions would be, I can see two situations. You have a 1-year lease, that hasn't expired yet, and, it's going to expire pretty soon, and you didn't get this exemption. Well, the simple solution would be wait till the 1-year term ends, and then if you're going to continue the agreement on a month-to-month basis, you would just have your tenant, before the lease expires, execute an addendum saying, hey, verbatim the language in Civil Code section 1946.2 subdivision E8. This property is not subject to the rent limits or the eviction controls in the Tenants Protection Act. It has to be verbatim from the Civil Code. You just put that in an addendum, you have both parties sign, and then boom, your property is exempt. Well, the other scenario would be, what if it's a month-to-month agreement? Well, you present an addendum to your tenant saying, hey, I need you to sign this. This is the law. Here's the exemption. I'm an exempt person. I need you to sign that. Because what if your tenant refuses to sign that? The Tenants Protection Act actually is written in a way where that could be just cause to terminate the tenancy if it's a month-to-month tenancy, to give a termination notice for cause because your tenant won't execute that exemption. And for a person that has an unexpired lease, and your tenant refuses to execute that addendum, like with their lease renewal, or at least make it a part of your rental agreement, basically, that could be cause after the lease expires. You would terminate the tenancy for cause for failing to execute that exemption. And we've helped a lot of landlords with this issue, with just pretty much writing a letter to your tenants. Hey, I need you to sign this addendum. It's just required by law. It's pretty straightforward. Here's a prepaid mailer. I just need you to sign it and just return it back to me, and we'll make it part of your rental file. So, boom, pretty simple. For those, again, landlords, property managers, if you're trying to figure out whether or not the Tenants Protection Act applies to you, if you need to get this separate but alienable, aka AB 1482 exemption, or single family home condo exemption, you can reach out to us below here. We help out landlords predominantly in Solano, Napa, and Contra Costa counties and the surrounding areas with this. If anything else, because these videos are going statewide here, you need to, if you're in a local area that controls eviction stronger than state law, you have a local eviction ordinance or a county ordinance, that type of deal, you want to talk with legal counsel of your choosing and determine whether or not the Tenants Protection Act actually applies to you or not, because you're only subject to the Tenants Protection Act or a local ordinance, not both, basically. It's one or the other. So you kind of need to figure that out. And then at that point, if it is a tenancy, a single family home or a condo, just with one unit on one title, basically, and you didn't get this exemption, talk with counsel about how to get that. But our solution is just presenting an addendum with that information. So, folks, until next time, hopefully that answers your questions if you have that concern. Until then, we'll check in next time. We'll talk to you then. Thanks.